Attend the court, please. The Honorable Supreme Court of the State of New Mexico. Please be seated. Morning, Council.
Morning.
All right, this is S-1-SC-35619, Padilla versus Torres. Can I have entries of appearance, please?
Good morning, Justices. I'm Freeman for New Mexico Legal Aid for the defendant, Helen Torres.
Good morning, Chief Justice. Larry Montano on behalf of Roy Padilla.
All right, Mr. Prettyman, it looks like you have asked to split your time 15 and 15. Is that correct? All right, you can take it away.
You can drink water first. And then,
We'll try.
that's okay.
I'm sorry, do I start?
Yes, you are free to start.
May it please the court. Metropolitan Court has the capability to record any civil case that comes before it, but there's an impediment to recordings being made, and that's that the rules require that a recording be made only if the litigant requests it. While vague language in the summons purports to notify litigants of the availability of recordings, that notice does not work. Most Metro Court civil defendants are there because of poverty-related issues. They owe money, or they're being evicted because they owe money. And they tend towards disability, poverty, lack of education, not understanding English well, if at all, especially written English. And they are by and large, not by and large, almost always unrepresented. It is clear the notice doesn't work for these folks. And the proof is in the data. Data from SOPA shows that at most 2% of civil defendants in Metro Court civil cases request recordings. And that just doesn't make sense because you need a recording to have a record for appeal. So that means that pro se civil litigants in Metro Court almost always waive the right of appeal before they ever appear in court in almost every case.
So the appeals are de novo, correct?
At the time this case was filed, and that is a great question because it's really confusing right now.
Right.
When this case was filed, tried, and appealed, all civil cases in Metropolitan Court pursuant to 34-8A-6
Right.
were on the record.
Right.
Okay. And the statute said the method and manner of appeal would be set forth by Supreme Court rule,
Right.
and Supreme Court rule that applied is 1-073 that said these are on the record appeals.
Ergo, not de novo, like they are.
Not de novo. Now, magistrate court, the statute for magistrate court says it's a not a record court, and appeals are de novo to the district court. So that's the difference between a metropolitan court and a magistrate.
I appreciate that. Currently, the standard is what? De novo,
It's split.
under 2019.
Um,
Metro Court.
Now, this is raised in a companion case before the court, actually two companion cases, and that is the issue is that cases brought pursuant to the Uniform Owner Resident Relations Act are heard not of record, and cases brought not pursuant to the Uniform Owner Resident Relations Act are heard on the record.
So dog bite cases currently on the record. Aurora cases not on the record, de novo, but that didn't start until 2019.
2019.
So we're focused on, to my mind, we're focused on that which predates 2019. And the idea there that in order to have the ability to effectuate an appeal was, I think your argument, in order to effectuate the appeal, that was undercut by the fact that the parties in that case, both landlord and tenant, would have to ask for a record in order to have any kind of review in district court.
Correct. And either party, not both parties, either party can request. As a matter of course, landlords don't request recordings historically, and
Because
tenants
typically they win.
because they win. So review doesn't favor them, and also during review, pursuant to the Uniform Owner Resident Relations Act, a tenant gets to stay in the unit, and as long as they pay rent. If they don't pay rent during the appeal, they might win the appeal, but they don't get to stay in the unit. But if they pay rent during the appeal, then they get to stay in the unit. So appeals don't favor landlords. Landlords don't need appeals. They almost always win historically.
So in this case, are you asking us to deal with kind of what I'll call the Group A cases, those that predate the change in 2019, issue a decision here that would potentially change, the lot in life for those folks that are in that pre-2019 category? Or are you asking us to address that and 2019 forward?
Yeah.
Both, Chief
Oh,
Justice.
so A and B.
And-
I'll use B as the 2019 forward.
And we'll call B1 and B2. B1 is the UWRA cases that are heard de novo. If you don't have a recording, you're not barred from taking the case to district court and having a de novo trial. So you're not bound by what happened in the court below. You don't have to point to error on the record. So this case wouldn't implicate that. However, in Group B2, the non-UWRA cases, they're still bound by the record, and there's still no record. And if you look in the companion case, it's the Erica Gallegos Cabrero, who I'm co-counsel, and it is also before the court.
Mhm.
There's an amicus brief filed by UNM, and they did a study of cases under the Mobile Home Park Act, and they pulled 94 cases out of, I think it was 7 or 8 months. And right now, although that's part of the case, Mobile Home Park Act cases, which are also summary eviction cases, very similar to UWRA, are heard on the record, and your appeal is on the record to the Court of Appeals,
Right.
pursuant to a joint administrative order between all the courts below the Supreme Court.
So going back to my original question, and the reason I asked it was I do want to be clear on the remedy with regard to this case as to other cases pending. Can you clarify that for me? Could we write, what would you suggest with regard to the remedy of this particular cases and then other matters pending?
With this particular case, Your Honor, there's no record. So there's 2 possible remedies that I see. One is a de novo trial in Metropolitan Court, where a new record could be created, and a trial be had. And if either side wanted to appeal, they could have a meaningful appeal because there were a record. The other remedy is a de novo trial, a de novo appeal in district court, because the New Mexico Constitution, at least in 2014, provided all appeals are de novo except otherwise provided by law. And here, the law kind of failed my client, I would say, or at least the rule failed my client. So the remedy is de novo appeal.
Thank you.
So the statute provides that Metropolitan Court is a court of record, at least the statute then, for all civil cases. And a court of record has to be a court that makes a record. And it's clear that a record is an audio recording in Metropolitan Court. Now, the court rules define a record also to include a stenographic transcript, but there's no stenographer in Metropolitan Court. There's a button to press and a recording's made.
Well, it's not that, it requires court monitors too. It's not just pressing a button. And that was one thing I kind of took issue with in the briefing, is it's not just pressing a button. There's additional staff and things that come along with it.
And I'll admit, I don't know those things. I do know that I've gone into court sometimes because I got a call at the last minute and decided to help someone. And I've asked the court orally for a record, and they press the button. I know one judge knows I'm going to ask for one, so she presses it right away. I don't have an estimate of all costs for the court monitor, but I think it has to be done because the court is a court of record.
So you think all cases should be recorded moving forward?
All on the record cases should be
Or,
recorded.
all on the record, which is a significant majority. Well,
Uh,
Everything but your.
yes,
Yes.
thank you. Everything but,
I'm gonna say about half the cases are URA cases, and the other half is Mobile Home Park Act, debt collection, contract cases, things like that. Now, and I would argue that the Mobile Home Park Act cases are URA cases, but that's a different appeal that this court might or might not get to.
But
And,
I understand the point you're making,
Yeah.
because when we make decisions in the past about eviction proceedings, we include both Aurora and the Mobile Home Park Act, because they are substantially the same issue. Just
Okay.
one is fixed and one is not.
So that's your view of what should happen, which is good. Is that a view mandated by the Constitution? And how? And let me ask you in this scenario, you also make a record, I assume, in your cases of the lease, right? Or there's some other paper record, not just the audio record.
There is paper, there are exhibits. Generally, the lease is attached to the petition filed by the landlord. There might be receipts, there might be pre-termination notices.
There could be things outside of what was filed with the complaint, right, that are the record.
Correct.
Is why, under your argument, and this may be fair or unfair, why shouldn't we mandate, if there has to be an audio record, mandate to make clear to the parties that they have to submit the paper record? It's a record. What you're asking us is to, in a way, compel the parties to make sure a record is filed for appeal. And what is the difference between the audio record and the paper record that the reviewing court needs to look at?
I think the difference, Justice Thompson, is that that without an audio record, you get no appeal. Now, you can file your appeal, but it'll get dismissed by the district court, and if you take it up to the Court of Appeals, historically it got dismissed by the Court of Appeals. And I believe it's State v. Moore where the defendant, the record wound up being inaudible for nobody's fault. And the court and the Supreme Court said, without a record, you don't get a meaningful appeal. And they meant the transcript or the audio record, and therefore we're remanding for a new trial because it impacts your right of appeal. If I don't put my Exhibit B into the record, I decide not to, or I forget to, I still get my appeal. I get all my other arguments. But without an audio record of the arguments I made, the arguments my opponent made,
You don't even get in.
you don't even get in. I mean, nominally you get to file your appeal, but it's dead in the water.
Spend $132.
So getting back to Justice Thompson's question, where does this right that you're asking us to enforce live? You know, there's been some mention of some statutes and the Constitution. Where does this live? Where should we find that this exists?
There's a right to appeal under the New Mexico Constitution. That's number one. And I'd have to say that right's meaningful. We don't get nominal appeals, you get a real appeal. And second, the statute says you get a court of record. And I've got one case that says that is a right, and I got to dig through. But the statute says it's a court of record, and I say that means make a record.
So instead of going back to Justice Vargas's question, so instead of, you're asking us to order that going forward, all cases be on the record, why wouldn't the alternative of amending the summons, which is really kind of what, in my mind, is a bit confusing for litigants, why wouldn't that suffice to make clear that if you're gonna want an appeal at some point, you need to request a recording?
I think there's several answers. One, the notice doesn't work. Or you have Spanish speakers, you have people with 8th grade educations, you have people with anxiety, PTSD, stress, families. They have a lot on their plate, and a lot of these folks are not going to request recordings. And we also make due process and equal protection arguments in our appeal. And equal protection talks about the least restrictive alternative. When you're trying to fashion a remedy to protect equal protection, you look at the least restricted alternative. And I think the least restrictive alternative is just recording every case. You know, we record every case in district court. We don't require represented parties. Almost everybody's represented in district court. How come we don't make them request a transcript or recording? But we make.
Maybe some would dispute that almost everybody's represented.
But I get, why do we have to
But
This
let
very-
me ask you this, Aurora cases where there, as I understand, it's de novo appeal, correct?
Now,
Now, is the Metro Court sitting as a court of record in a Aurora case
we
under the
request,
statute?
no, it's requesting, it is sitting as a court, not a record, although you can still request a recording, and the judge will say, this is a request for recording in a non-record case, which I think is right. And there's reasons to request perhaps to reserve testimony, to make sure that someone
There's
doesn't
all
change
kinds
their
of
story.
reasons. I was just wondering, sometimes it's a court of record, sometimes it's not a court of record. Is that right?
And I'm confused, and I guess it's the folks in the roundhouse that have to correct that. But what if I raise non-UORA and UORA claims or defenses usually in a case?
Yeah. in the
Is
same
some of it
case.
on record and some of it not? I don't know.
Gotcha.
All right.
Um,
You've run out of time. You'll
I'll
have more
make-
time in a minute, and we're going to hear from Mr. Montano. The conscripted.
Good morning, Chief Justice.
Good morning.
May it please the court. This appeal raises very important issues that implicate the justice system in the state of New Mexico. It concerns issues of poverty, of literacy, of homelessness, of access to justice. These are very big issues that are of concern to this court, to New Mexico Legal Aid, to myself. No one is perfect, and even the best intentioned rules can have issues. And when those challenges are brought to this court has the authority to review, to address, to amend, to withdraw. And that's why we're here today. Mr. Torres, represented by very capable counsel, contends that his right and the rights of all other pro se litigants in the Metro courts have been violated pursuant to rules that this court has promulgated.
Mr. Montano, let me ask you a question right off the bat about the rules. One of the big problems I'm having with this case is the discrepancy between the rule setting out what needs to be in a summons and the summons itself. The rule setting out what needs to be in the summons says that must be in substantially the form approved by the Supreme Court and must contain, and I'm talking about Rule 3202, B4, a notice that the defendant may request before any proceeding that the proceeding may be recorded. That notice shall advise the defendant if a tape recording is not made of the proceeding, it may effectively preclude the defendant from appealing to the district court. You may be effectively precluded, but when you look in the language of the summons, it is not that strong and definitive. It says that if you don't ask for a tape recording, you will not have a record of the proceeding to take to the district court for any appeal. It doesn't say you may not get an appeal. It says you may not have a record, which I think is different. How do we address this discrepancy between the rule and the summons that I believe Mr. Torres received?
Justice Vargas, I noticed the same dilemma, and it is raised in Mr. Torres's briefs. I think that that is something that this court can correct, and it should correct it to the extent that your honors feel like there is a material difference between that language, then it is something that can be corrected.
How does it affect Mr. Torres's right to notice?
I think it does not affect his right to notice, and here's why. In addition to the rules that you just mentioned, there are other rules. And I understand that many pro se litigants are not going to familiarize themselves with the rules. But if you look at the summons that was issued in this case, which was on the court-approved form, it does tell all litigants, pro se litigants, represented litigants, what it is that they must do in order to have a recording made at the Metropolitan Court. Now,
But
in
it
that,
doesn't tell people what the effect of not having a recording may result in?
To me, when I read that language, I think that it would.
You're talking about 3202 language, not the summons language.
That's correct.
Okay, I just wanted to.
That's correct. But I think the broader problem with Mr. Torres's appeal, candidly, is he raises due process concerns, but then he says that essentially no amount of notice and no amount of an opportunity to be heard would rectify the problem. When you hear these points that have been made here today and in the briefs, what is the contention? These people cannot read. They don't understand what they do read. They don't understand the legal process. And all of those things might be true, but they can't be rectified by magic language. And that's the problem, is that in a situation like this, Mr. Torres, who can clearly read, he can clearly write, he can clearly follow instructions, we don't have a record of what he took that language to mean, if anything, if he even read it. That same summons tells him and others that they have the right to file an answer. He didn't file an answer. And to Justice Thompson's point, is a record is not what Mr. Torres believes it to be. A record can be any number of things. It includes the complaint. It could include an answer.
But the paper record doesn't give somebody the opportunity in district court for effective review, because I know very personally, having been in that a district court judge along with Thompson handling these cases, if there's not a record, see ya.
Yeah.
And so the paper record doesn't take us all the way up.
Yes, I think that's another dilemma, though, Chief Justice, because take this case, for example. Mr. Prettyman, who I have a great deal of respect for, and New Mexico legal aid in general, he's identified certain concerns that his client had. Potable water, holes in the walls, leaking roofs, falling cabinets. Chief Justice, just consider, what if there had been an audio recording of that proceeding in Metro Court?
Mm-hmm.
And Mr. Torres then appeals to the district court sitting in its appellate capacity before the Aurora amendments.
Right.
So a district court looks at that, and what would Judge Barella Shepard have done? She would have said, okay, I've listened to the recording. Mr. Torres says A, B, C, and D. Mr. Padilla denies it. Where is your evidence? Where is
But at least there's an opportunity for somebody to be heard, even if Judge Barella Shepard says, that the evidence doesn't support the tenant's claim, that there's a lack of sufficiency of the evidence for that, and affirms on a deferential standard fact finding. At least they get the opportunity to do that under the pre-2019 structure, unless somebody understands that they need to ask for a recording to have that opportunity. It doesn't exist.
I think, Chief Justice, that's the dilemma that we're presented in any number of appeals. As we pointed out in our papers, this court and the Court of Appeals routinely dismisses appeals, rejects appeals because of the failure to comply with rules. That can be as simple as filing a notice of appeal. That can be as simple as filing a cert petition. And
I take that point, that your failure to file an answer, you get a default judgment, all of those things that we know happen all of the time. But here, there's two things that trouble me. One, we have different rules for Metro and Magistrate Court, period, that are different than the District Court. So even though we have this rule, and I don't know how many times I said, I have to hold you to the same standard as somebody represented by counsel. Said it probably 1,000 times. But we have different rules and standards in Metro and Magistrate Court because they are different types of courts, a different type of population. For example, an LLC that is a landlord can represent itself in Metro and Magistrate Court. You can't do that in District Court. And it's because there's a recognition in Metropolitan Court and Magistrate Court that we are dealing with a different population. So if that is true, why don't we, own that, so to speak? Because the onus is on us. It's not on you guys. These are our rules.
And our form.
Yeah, and our form. So why don't we own that as we treat this population differently because of the type of population than the type of cases. So that's one thing. The other is, I believe, and I'm really bothered in this case, that when the court speaks, it needs to be accurate. And that goes to Justice Vargas's point, which is, sure, we have a rule of civil procedure that says effectively preclude. We all know what that means, but I'm not sure anybody else does. But then we speak again and we tell them something different. And isn't that a problem? And again, a problem that we have to own, not the litigants, not the lawyers.
I certainly understand, and I think that's your prerogative to do. But the real question, and I think that Justice Vargas also raised this question, is does that rise to a constitutional level? That's the issue before this court.
So taking the hypothetical of an appeal, and there's no pictures of the damaged apartment, so on and so forth. Taking the Prettyman's argument to the next step is that now they need to be counseled to bring pictures of the damage.
That's
And if
correct.
they don't, they're somehow being deprived.
That's correct, Justice Beal. That's the dilemma, is that where do we begin and where do we end? As a practical matter, I can understand, Chief Justice, why this court, as part of its rulemaking authority, would say, we need to correct this, or we need to change this. To Justice Zamora's point, and certainly Justice Zamora and others of you would have a much better sense of this than I do, relative to the state budgets, relative to the administrative imposition on the metro courts. I identified certain concerns in my brief, just as a practical matter, what it takes to get something from point A to point B. And it's not so simple as just pushing a button, but that's for your honors to determine. And for the legislature to decide, if there's enough money to go around. But to Justice B. Hill's point, where does that end? The New Mexico Legal Aid says, well, this is essentially a waiver of the constitutional right to appeal. Well, who's entitled to that advice from any judge in any kind of civil proceeding?
Why isn't it a due process? Setting aside equal protection, because I have questions about that argument. Why isn't it a due process problem, given what I just described, that the court is speaking and contradicting itself? Why isn't that the path here for us to declare that we've got this discrepancy, it was wrong, and we need to fix it?
I don't think it presents a due process issue.
Why not?
And it does not present an inconsistency. What I have heard the court say, and I've seen it myself in comparing the two, is that one is more generic than the other. One describes, in essence, the outcome or the likely outcome that would occur in the event that you don't request an audio recording. But that's not a contradiction. That's essentially an elaboration on what is presented in other rules. So I don't see this as a conflict where, and that is, by the way, very different than some of the other authorities that we have talked about in the parties' papers, where this court has identified situations where the court rules very much do conflict with the Constitution or with the statute. For example, the state's ability to appeal from certain decisions, where according to the Constitution, the state may appeal various things, but then by court rule, the Supreme Court had limited the ability for the state to appeal certain kinds of things, obviously all subject to double jeopardy. concerns. So we really don't have a conflict here. And again, I go back to the notion of what is due process. It's notice, and it's an opportunity to be heard. Within the summons, all litigants are told the same thing, and they are directed to other rules and other laws, and someone who is interested in knowing about how to present their case would certainly have an opportunity to do that. That's what due process requires. And it was fulfilled in this case because there wasn't anything where somebody showed up to court and all of a sudden it's at the discretion of the judge. Am I going to record? Am I going to push the button today or not? For this person I will, but for this person maybe not. It's not that. All litigants are told, if you want a recording, then this is what you must do. And I would liken that to other situations. I've already talked about notices of appeal and the mandatory precondition that you file at the right time, that you file in the right court. And we see that in both Metro Court proceedings, District Court proceedings, and all other kinds of proceedings. But let's talk about the constitutional right to a jury trial. We have Rule 38. Rule 38 says, you want a right to a jury, you have to request it by a certain time. So somebody could come forward and say, just a second here, I have a 7th Amendment right to a jury trial. I didn't get it. And a court can say, but you were alerted to the fact that you had to make that request in advance of trial. And our rules would say that you have to request it even sooner than that.
But see, in this case, and this is really, really bothersome to the chief's point, Rule 3708 says one thing, 3302 says part of what 3708 says, but then adds something, and then the form says something of part of what 330, it says everything that's required by 3708, but it only says part of what's required by 3202. So, I mean, there's and then add on that, there's confusion and there's within the court itself, when is it a court of record, when is it not a court of record? And it just seems like this is all, is that really notice? Is that constitutionally adequate notice?
So it sounds like this is your opportunity to say this is an us problem.
I think he said it a few times. He's like, oh, thanks for inviting me to this party.
Respectfully, it is. And at the end of the day, I think that what this court is most interested is in getting it right. And certainly I can understand the pluses and the minuses that are at issue here. But I would say, and I think that my papers reflect this, is that this does not present a constitutional problem. It may pose, I would go further, I would say it does pose a pragmatic concern. But again, I think that you're in the best position to evaluate whether it makes sense and whether it is monetarily feasible to require the Metro Court in all civil proceedings to record every single one of those proceedings.
We're asking the legislature to make it so. So I think
Okay.
we probably passed that obstacle.
Okay.
But you wouldn't know that, Mr. Booth.
And that would certainly be a fair request by this court. But to address the problems themselves, we've identified various cases in our brief where this court and the Court of Appeals have each said in different settings, including in one instance in a Aurora setting, that the failure to comply with the rules of civil procedure and the consequences of the failure to do so does not rise to a constitutional level. This court has said that in the criminal context. And so when we're talking about the civil context, the standard is even less. So if one can say in the criminal context where a party has a constitutional right to the effective assistance of counsel has all of these other rights that are critical when the state, is presenting, prosecuting the claim. If that's true in the criminal context, how can that not be true in the civil context? That, I think, is the real issue here, is that you have a set of rules, you have a summons, you have other rules of civil procedure, you have statutes, all of which talk about what it is that you must do as part of your case from soup to nuts. And in this instance, I think it's important to kind of go back to first principles, because I think that there is some confusion by Mr. Torres about what it means to be a court of record. And I think, Chief Justice, you hit upon it, which is that essentially there's a dichotomy between on the record and de novo. But that speaks to the kind of appellate review that someone is entitled to if they take an appeal from a lower court to an appellate court. It doesn't mean that a Metro Court judge or a district court judge or any other kind of judge is obligated to provide a specific kind of record, or that a record is not a record if it doesn't include everything that might conceivably be included within a record, including an audio recording. Certainly, I have had my own experiences in bench trials, for example, where depositions are tendered to the judge, but then those depositions don't make their way into the court record. Is that something that can be considered on appeal? Maybe, if corrected before it gets to you. But again, the notion is that your record is your record. You're responsible for creating that record.
But Mr. Montano, Mr. Prettyman's argument is that this is a certain class of litigants that require, because of the nature of this litigant, due process may require more to be provided to them than to a sophisticated business person. They don't have the means, they don't have the wherewithal, they don't have, they're behind on their $700 rent. How are they going to go hire a lawyer? And so forth. Doesn't that play some role in the issue of due process here?
Yes, I think it
Did you
does.
see that?
Yes, I think that due process must comport to the circumstances. But in this particular case, and obviously your honors have to be concerned with all cases that we can conceive of when you're developing your opinions, my client was unrepresented. My client, did not request a recording. And this notion that, but landlords always win and tenants always lose. I'm not going to represent to this court what my client knows or does not know, but wouldn't that argument essentially assume that landlords are aware of the winning ratio in metropolitan court? Wouldn't that require the assumption that they know, hey, we're just going to go in there, we're going to steamroll?
But I think that the class that at least I was talking about, and I think Justice Fields probably there too, is that this is a large universe where everybody is unrepresented. And so doesn't that call for a different set of rules to the game? I think it's that both sides are largely unrepresented that undercuts the equal protection argument here, but not so much the due process problem that I see. So I think if we're looking at the group as a whole, regardless of whether they're the plaintiff or the defendant, they suffer the same challenges, especially if we are not clear when we speak.
Yeah, I understand the issue that you're presenting here, but again, I fall back to the argument that the assertion is that with this population, they don't know how to read. They don't understand what they read. They may not read English at all. They might not understand English at all. So under those circumstances, this court has to ask itself, does it make sense to say that this is required as a matter of constitution, as opposed to saying as a practical matter, if it saves one person from losing his home, we're going to do it. And I can understand why this court would do that, and why it is that you've already requested.
So is it your contention, position, probably all the those are too strong words, that this court can declare that what we have done heretofore is not terrific, we are going to fix it, and what then does that do to the appellant here? Do we then say, all right, you get a do-over, and not tether it to the Constitution?
First of all, Chief Justice, that is what I'm asking for this court to do, is to say, certainly you can do it better if you so decide, and if it's...
I think everyone agrees we can do it better.
I say that...
But I think there's a lot of arenas where we can be more clear about what we mean.
And also with limited resources, right? And again, I may be thinking too much about this and the expense and whatnot, but I don't think it's so simple as just pushing a button. But yes, I think as a practical matter, all other things being equal, resources not being scarce, by all means, you can request that, but it's not a matter of a constitutional
I understand the
dilemma.
distinction.
And I think that this is a slippery slope that the court is being invited to go down.
Well, let's explore that. It seems to me like the rules point to the idea that constitutionally adequate notice will be provided in the summons. And that the summons in this case did not comply with these rules, or at least one of the rules. I think it complied with one, and so it did not comply with the requirement constitutionally to give adequate notice, that the interplay of the rule and the form was intended by the court to give constitutionally adequate notice. This is what you need to do. And that in this case, it failed. Am I going down the wrong path there?
I think you are,
Tell me
Justice
why.
Hill, and here's why. And it goes back to something that Justice Thompson noted. A record, as we all know, can consist of many things. So how does the summons address that? What the summons speaks to directly is the need to request an audio recording. So how can it possibly
But the rule does more than that. It provides that if a tape recording is not made of the proceeding, it may effectively preclude the defendant from appealing to the district court. Not just to request a recording, but that if you don't, this is the consequence.
Notice the language, though, Chief
I know
Justice
it
Hill.
may. I know.
May.
Yeah, I understand.
And why is that word so important? Because a record can consist of a lot of things. And in this instance,
So do we issue a rule directing all trial courts that a paper record is sufficient and do your job? Because here, under the original rule that we're talking about, these cases were being flatly dismissed out of hand because of lack of a recording. So is there a fundamental misunderstanding at the trial court level?
yes.
I mean, that's the,
I believe so.
I think that's an interesting point. I mean, I was wondering, to carry that point, reading her order, whether she was saying, the trial court judge, I mean, jurisdictionally you're out, or I don't have a record, I can't decide this, you didn't make a record, you're out. To me, those are two different things. And
but I don't know how jurisdictionally you'd be out without her
Right.
assuming that without a recording, there's nothing I can do.
right,
I will tell you, when I read the order, my initial reaction is, are you dismissing it? Are you denying it? Because at the end of the day, even lawyers in context where they should know better, how many times have you reviewed, hopefully not too many as the Supreme Court, but bills of cost bills and things of that nature, and people just, submit a piece of paper and say, this is how much it cost. And a good court would say, where's the backup for this? Where's your billing records? Where's your receipts? Where's all this other things? And ultimately, what I'm saying to you is, in a situation like this, having an audio recording isn't going to change the outcome. And while as a society, we may want to remove as many obstacles as we can to a party being able to present various issues on appeal, that doesn't mean that because in our rules at this time, when this matter was before the Metro Court didn't have this requirement, that somehow that's unconstitutional.
But let me push a little bit on this, because let's say it was a simple dispute over whether the lease was paid, and it's a paper record, and and the paper, it's all attached. I got the lease, and I've got a canceled check. And the court says, you don't have an audio recording, you're out. They still, and Metro Court says, I'm gonna side with the landlord. But there's a record that says I paid, or I made up the payment, or whatever. It seems to me the problem here with this judge is, I'm not even gonna hear it.
I agree with
And
that.
that's where I think his argument is very compelling on the right to that discretionary appeal.
Well, I was thinking along those same lines, but ultimately reaching a different outcome. In the sense that if that were the issue, I am being told that I haven't paid rent. What are you saying I haven't paid rent? Here's my canceled check. Then that would be reviewed on appeal. Audio
Not
recording,
if the trial court's gonna say you're out because there's no audio recording.
I think that this court can make clear that the proper disposition, because in non-Aurora cases, this may still occur, post statutory amendment, is that if that is presented to you, don't dismiss as a matter of course, but you must evaluate whether in this situation, you're able to review the matter. And that's what I'm getting at, is that in that very discrete situation, and here, by the way, Chief Justice, it was an oral lease. So it wasn't even the kind of thing that was attached to the complaint. You see what I'm saying? So in that situation, when you have two people going before a very seasoned Metro Court judge,
Yeah, I agree with that.
okay, and he's listening, and my client is saying, they haven't paid rent. And Mr. Torres is saying, we haven't paid rent, but we don't have to pay rent. And here's why. In that scenario, that is why Judge Barella Shepherd got it right. Now, I would not have used the words that she used, and I think that it may be worthwhile for this court to explain that, but I don't think that it is appropriate or necessary for this court to say, ipso facto, that rule is unconstitutional.
I follow you. Thank you.
Thank you.
Come on up.
Mr. Prettyman, before I forget, assuming your client was represented by counsel at the Metro Court trial, same things happened, no request for a record, it's appealed, it's dismissed for lack of recording. Same result that you're asking for here today?
Yes.
Why?
First of all, that counsel wasn't me, because I would have requested it. Because I would have been malpractice for me not to.
And the other thing that, and you can answer, when you request a record, is there a charge for doing that?
No, there isn't.
And they're not told that, see, I mean, anyway, but
There is a charge if you can have the record reduced to a CD,
And then there's a
and it's
charge.
$5.
Okay.
And it takes several days to get.
but to get back to the counsel, that's the reason.
It's a court of record. The record should be made. I disagree that a record can be a paper record. If a record can be a paper record, what's the difference? Why is a magistrate court a court of not a record and a Metro Court a court of record? Because if I appeal for magistrate court under 1072, the magistrate court transmits the record to the district court, and of course the district court, it's a record proper, I think they call it.
Yeah.
It's paper record, but it's still de novo review, and it's clear from precedent in this state and other states, you need an audio record or a stenographic
So
transcript.
can I ask you, because the rule and the summons, I don't think there's anyone sitting here who thinks it's written well. I mean, there's no question. But I guess where I'm struggling is whether this rises to the level of a constitutional violation. Because I think Mr. Montano made a good point. I mean, the right to a jury trial, even in a criminal metro case, in certain levels of charges, or a traffic case, certain levels of charges, or a civil case elsewhere, if you don't file your demand for a jury trial, it's waived, and there's no summons, there's no notice, it's just the rules, and a lot of those individuals, particularly in metro court, are pro se. I mean, are we saying that because we don't give them proper notice that they need to file a demand, that rises to the level of a constitutional violation?
I'm going to feign a little bit of ignorance because I don't know a lot about requesting a jury trial. I've never done one. However, I would say that I have requested a jury trial, and I know there's a decision to be made, and a lawyer is probably in the best position to make that decision. Just like with paper exhibits, sometimes you want to submit them, sometimes you don't, because it might hurt your client, it might help your client. You don't know, and you have to make a judgment call. And the judge can't tell you to, the clerk can't tell you, yes, submit it. But you always want a recording. You always want a recording if you're a tenant or a consumer debtor in Metropolitan Court. There's no judgment call. You want it. Who waives their right of appeal? And this court I applaud this court's efforts to promote access to justice. It has a reputation for doing so, but I think the right of appeal in Metropolitan Court is a gap where people are falling through. They're not able to access appeals. And these are, with regard to your proceedings, these are summary proceedings. They happen, trial scheduled in 7 to 10 days. Tenants are all unrepresented except for a small percentage, 1 or 2%. Landlords about 25%. There's no pretrial disclosures. You don't know who the other side's witnesses are going to be or what their exhibits are going to be. There's no discovery. Judges get slammed. Metro Court judges get slammed. Judge Fitzwater, on the day of this trial, had 23 settings, including a 3.5-hour bench trial.
Mr. Prettyman, when the court files a judgment, I haven't seen one of these in a little while, is there anywhere that the defendant or the tenant is told, you have a right to an appeal. If you want to exercise that right, you have to file a notice, da, da, da. Is there anywhere that a defendant is told that?
In Metropolitan Court, I don't believe so. I think it says something about if this judgment is appealed, the stay of the judgment, stay of the eviction can be obtained under Section 47(8)-47.
Can you address Justice Vihill's concern about if we were to rule in your favor, this would basically create a slippery slope where now we have to, in the summons, include language that if you want a jury trial, you have to do this. If you want a recording, you have to do this, and this is the consequence. If you want to appeal, you have to do this, and this is the consequence if you don't do it. How do we keep from turning our summons into it's already like a 4-page document into a 10-page document? Or is that where we're headed?
I don't think the court's headed that way. I think it's an easy call to record all civil trials in Metro Court if they're supposed to be on the record, because they're on the record. These other things are calls to be made. Do you want to appeal? If someone calls me with a judgment against them, I often say, you're going to lose your appeal.
But one of your claims is that the tenant here did not have proper notice that he needed to request a recording in order to exercise his right to appeal. So my question is, does this create a slippery slope where we have to notify tenants of other constitutional rights they may have so that they can exercise those rights? And, maybe it would be great practice to do that. The question is, are we constitutionally required to do that?
I don't think so. And first of all, if you had too many notices in there, less is more, more is less. And it wouldn't notify anybody of anything if there were 20 things that they had to think about. But I think that the difference here is the statute requires the court to be a court of record, and no record is made. And I think notice is a red herring. I think we're blaming the tenant for not doing something that the court's supposed to do in the first place. So with all due respect, I'll blame the courts. I believe the court should be recording all these trials if they're on the record because the statute says so. Otherwise, I don't know why we have on the record and off the record cases, because every case has got a paper record. And
So you're saying the record means the paper pleadings that are there and includes a tape recording or a record of the proceeding?
yes, the case law will say, Justice V.
It's
Hill,
both. It's not just one to the exclusion of the other, it's both.
correct. The case law will say that the purpose of a record is to have a meaningful appeal. And we know that you can't have a meaningful appeal without an audio record. And the court rules on recording proceedings define a record as an audio record, a stenographic record, or a statement of facts agreed to by the parties, which will never happen because, among other things, Mr. Montano and I weren't at trial. We can't agree to anything that happened. None of us know. And so a lot of the cases on missing records, there's a line of Fifth Circuit cases that will say one of the things is we always have different counsel of appeal, and the purpose of a record is to tell appellate counsel what happened down there, so they can point to error, and they can't point to error if they don't know what happened down there.
And I'm reminded of a case back in the days, I guess they used to do CDs. No, cassette tapes. Used to get boxes of these cassette boxes. Those were expensive. But anyway, there's a criminal case on the books where the recording equipment malfunctioned. And the court remanded for a new trial on the basis that the defendant's right to appeal, constitutional right to appeal, was irreparably damaged because of the equipment failure. Does that add anything to?
Yes, I believe that's State v. Moore.
Is that it's
And it's like 1975.
yeah.
And whatever the concerns with cost, they have to be much less these days.
Yeah,
With
we went from
electronic
cassette
recording.
tapes to DVDs to now electronic recording.
I'm sure they had Victrolas back then. And in these cases, getting back to this judge had 23 cases that day, and even the most seasoned judge is going to make an error. Everybody makes mistakes. These are really quick cases. They last minutes. It's a trailing docket, and so there should be a right of appeal to act as a relief valve for these cases and correct errors. And that's the way it should be. It should be very efficient because we don't want to make Metro Court expensive when you have pro se litigants going in and doing these things for relatively small amounts of money, although they're large amounts of money and really big things for my clients who might be homeless. But you want to have an efficient system, but you need a relief valve where people can get review if an error is made. Because in such a, they call it MASH, meatball surgery, perhaps meatball judging. And that's by design. It's a balancing of interests. But we need to have this relief valve, and we don't have this in on the record cases because it's 2% of the pro se tenants who are requesting recordings. And if I were advising these tenants, if I would think that if any one of your honors were advising the tenants, they request a recording. You don't automatically waive your right to appeal. Don't do that. So I do believe it's a constitutional issue. I do believe it's a statutory issue.
I don't think it's, correct me if I'm wrong, but I thought you were arguing a statutory issue. That is, that it's a court of record by the statute, and not recording every case is a violation of the statute.
I am
Not a
arguing.
constitutional violation.
Mhm.
Is that the argument?
Yes, and it's
Or
also
are you trying to say, in addition, it's a constitutional?
in addition, Your Honor, because the Constitution says you shall have a right of appeal. Appeal shall be de novo unless otherwise provided by law. Law says it's on the record and it's an on the record proceedings, but that's not being provided. So I believe the otherwise provided by law is failing, and the whole system is failing the litigants in preserving their right to appeal. And I think also not requesting recording is a waiver. It's a waiver of a right to appeal. And by saying you don't get an appeal because you didn't request a recording, you're making it a constructive waiver. However, how do we know that you waived the right? How do you know that it was knowing, intelligent, and voluntary for this?
How
Pro
would you
se
know
litigant.
with the jury trial? It's the same, I mean, I guess I actually understand your statutory claims. I think in my mind, it's stronger because we don't know if those pro se litigants who are charged with, you know, somewhere between 90 days and 6 months, who usually are representing themselves, know that they didn't waive their right to jury trial by not filing a demand within 10 days or whatever the rule requires. In my mind, it's the same thing. With all that said, I do agree with what you're suggesting for the future. I'm wondering about the constitutional violation as opposed to statutory. Just don't see the difference between that jury trial right and the appeal right. I think if we say that there's a right to appeal and we didn't properly advise them, we got to start advising every litigant of every possible constitutional right they're waiving, and then like go even a step further that you're suggesting is doing it knowing, intelligently, and voluntarily.
Well, I guess I have a practical response, which is due process and equal protection, and generally involves balancing, and where someone should always want a right to appeal, whether they're going to appeal or not. They should preserve that. No one is going to say before they ever step into the courtroom, no, I waived my right to appeal, versus jury trial or other rights where you might want to, you might not want to. I think it's an easy call to say, let's preserve his right of appeal. Let's make a recording of this trial.
But for the reasons we've already said, I not requesting a record, not requesting recording, it does not ipso facto in all cases mean that you are waiving your right to appeal. A good lawyer like you or Mr. Montano may have strategic reasons to say, I don't want a record, but I don't want a recording because I have enough stuff here in the pleadings and in the papers to do an appeal if one is necessary. And all this other, a recording won't really add anything.
I think it does, because how do we know if that lease that's in the record was properly admitted? What if someone said, that's not my signature? What if that exhibits? What if that's that canceled check? The landlord says, I didn't. That's not my signature.
A lawyer may have strategic reasons for not requesting a tape recording.
I would not.
I'm not saying, neither would I. Period. I mean, I'm gonna ask, but that's not the issue. I think the statement, the bold statement that not requesting a tape recording equals a waiver of the right to appeal is probably too strong. Doesn't satisfy all cases. That's all I'm saying.
Well, I've got the red light.
Uh-oh.
The dreaded red light.
No, I'm very grateful for it. Thank you.
Thank
All
you.
right, counsel, thank you to both of you for standing up to the challenge of this case, and because we know it also affects another series of cases that have languished in this court because of lack of counsel. So we really appreciate your earnest efforts in that regard. The case as of today will be deemed submitted, and we will get you a decision, whatever that may be, as soon as practicable. We really appreciate your time today. Thank you.
Attend the court, please.